There are safeguards that can be put in place in terms of succession planning in the event of incapacity in future. The main one is to make sure that you have a will in place, a valid will that you put in place while you still have capacity to be able to deal with your affairs following your death in the way that you intended. The other thing is to make sure you've got powers of attorney in place. These are really important in terms of decision making while you're still alive, but to appoint a trusted person that you want to make decisions for you if you do lose capacity. They might be signed while you've got capacity, but if you were to become incapable in future, they will extend into that period. And they govern decisions such as financial and legal decisions, medical treatment decisions, and also personal welfare decisions. When we suspect there's a loss of capacity, we like to see a client in person. When a client visits us, we do form a view as to what their level of capacity is, and we generally presume that there is capacity, unless there's a red flag or there's a reason to suspect that there isn't capacity. If that happens, the practice that we like to follow here at Hall & Wilcox is to make sure we refer that client to a medical practitioner for a formal assessment. It's becoming common to actually use a geriatrician in those circumstances because they're experts in determining whether someone has testamentary capacity. If there's no prospect of someone becoming capable of making decisions, so they've lost capacity and it's unlikely that they're going to recover capacity, there could be an issue. If they do not have a will, there is a means by which a court can make a will for them, and it's called a statutory will. It can be a complicated procedure and it's not ideal because we're relying on a court to actually infer what a person's intentions might be, and they may not describe what a person intended. With regard to powers of attorney, it's too late. If someone has lost capacity, we're unable to put them in place for them. But a tribunal might be able to appoint somebody to be able to make a decision for them, both in financial and legal matters and also in guardianship type matters. The best thing is to get some legal advice and work out the best option.